He forced you?
Yes.
At
gunpoint, yes.
Stuck a gun at the back of his head, just as you done with Scott Davis, pulled the trigger, and shot him in the back of the head.
It was an emotional moment as the children of a murdered San Antonio woman confronted their father for the first time since he killed their mother just over 2 years ago. Brian Ramos was convicted in the shooting death of Josephine.
You made a bad decision. It's not fair.
Moments after Judge Jennifer Pina announced that Brian Ramos was convicted of murdering his wife, their daughter stood face to face with him, filled with emotion.
You exist. You're standing right there. My mom is ashes now.
Ramos was swiftly arrested after shooting and killing Josephine Ramos in a parking lot on Goliad Road on April 1st, 2000, just 1 day before the couple's divorce was scheduled to be finalized. He has been held in the Bexar County Jail ever since.
Mr. Ramos, to the offense of murder, what do you plead, sir?
No contest.
I'm going to find you guilty.
I was 14. It's not fair that I have to graduate and none of my parents are there.
Josephine's sister and son also expressed their feelings directly to Ramos.
Brian, I have so much hate in my heart for you. But all I can hear is my sister say, Monique, forgive him.
I met my brother and sister, but I could look at you eye to eye and not look away.
And you can rot in jail, and people can hurt you, and you're gonna finally know what that feels like. How you always used to tell me that actions have consequences, well now here you go.
Brian Ramos has been sentenced to spend the next 35 years in the Texas Department of Corrections for the murder of his wife, Josephine Ramos. His attorneys mentioned that he will be eligible for parole during that time. Jeremy Christian was found guilty of murdering 2 people in Portland, Oregon. The incident occurred on a crowded train when he suddenly launched into a racist rant directed at 2 young women. Bystanders attempted to intervene and stop Christian during the outburst. Unfortunately, the situation escalated, resulting in Christian stabbing and killing 2 men and seriously wounding a 3rd. He fled the crime scene, but train passengers followed him, and he was apprehended about a mile away. During his arrest, Christian was seen in the back of the patrol car.
I'm happy as a motherfucker. Hopefully this motherfucker dies.
Christian was later convicted of 2 counts of murder and attempted murder. During the sentencing, one of the victim's family members delivered a victim impact statement, which prompted an outburst from Christian.
Mr. Jeremy Christian, your mom should have swallowed you. You are a waste of breath, and when you die and go to hell, I hope you rot.
See you there. You ain't gonna be married either. You ain't gonna be married either.
After Christian was escorted out of the courtroom, the judge sentenced him to 2 consecutive life terms, along with an additional 25 years for his other convictions. Susan Mellon was sentenced to life in prison without the possibility of parole, based on false testimony. At 42 years old, she was arrested in Los Angeles, California, at a McDonald's while taking her daughter to get a Happy Meal. Unfortunately, that would be the last time she saw her child for 7 years, as she was charged with the murder of an ex-boyfriend.
You are under arrest now for murder.
I wouldn't do that.
Mellon's conviction relied entirely on the testimony of an informant who claimed that Mellon had confessed to the murder. She spent a total of 17 years in prison until it was revealed that the informant was a pathological liar and an unreliable witness. Now, this marks the moment when Mellon's case is finally overturned.
The judgment is vacated, the conviction is overturned, and as to Ms. Mellon, the case is dismissed.
From tears of sorrow in one moment to jumping for joy in the next, Mellon celebrated her release by finally taking her daughter to McDonald's to deliver that long-awaited Happy Meal. The state of California awarded Mellon $597,000 in compensation, and reports indicate that the Los Angeles City Council agreed to pay her $12 million. And 6, she wants them dead. That was the message from the daughter of a murder victim as the three suspects appeared in court. Angelica Ramos expressed that her mother didn't have to die in such a manner, emphasizing that no life is worth losing over a gold chain.
She was my best friend. My mom was everything I had to me. And there's like an emptiness in my heart now without her.
Angelica Ramos was inconsolable as she stood outside a Kern County courtroom, attending the arraignment of Christopher Patterson, Maximilian McDonald, and Lawrence Slaughter. The trio is charged in the death of 71-year-old Guadalupe Ramos. Police report that Patterson snatched a gold chain from Guadalupe's neck in the Foods Co. parking lot on Haley. They state that Ramos fell and died from blunt force trauma to the chest, which triggered a heart attack.
Furious, angry, upset that my mom had to die in this manner. You know, because of a chain, it's not worth it.
Police reported that they were able to track the suspect's movements before and after the robbery because Slaughter was wearing a GPS ankle monitor as part of his parole. Authorities followed Slaughter's GPS movements and confirmed that the three were at the Foods Co. during the time of the murder. Additionally, security footage from the store captured the attack. Meanwhile, Patterson, seated in the back row, openly laughed during the hearing.
That disgusts me. That person should get death penalty, matter of fact. And I'm going to do whatever I can to make that happen. To see who's going to be laughing once he's San Quentin.
The district attorney stated that the three suspects were gang members and would be tried together.
All three of the defendants are members of a criminal street gang. Therefore, the gang unit of the Kern County District Attorney's Office will be handling this case.
Now, the victim's daughter is left to struggle with her grief as she awaits justice.
She didn't have to die like that.
All three suspects are scheduled to return to court on September 19th. The accused Craigslist killer took the stand himself. While it will ultimately be up to the jury to decide, prosecutors believe that Richard Beasley fabricated elaborate stories to conceal his involvement in the Craigslist crimes. On the stand, Beasley shifted blame to several individuals for the murders, but did not accept responsibility himself. In a move that surprised many, Richard Beasley stood up from his wheelchair, took the witness chair, and denied any involvement in the Craigslist killings.
I had no idea that anybody had been killed down there on that farm. I had no way to know.
There were tense moments during cross-examination when the prosecutor accused Beasley of luring Ralph Geiger to Southern Ohio and murdering him.
Stuck a gun at the back of his head, just as you done with Scott Davis, pulled the trigger, and shot him in the back of the head.
You're a liar. I did not do that. And you didn't see it. Nobody testified to that in this court. It did not happen.
Prosecutors assert that they have overwhelming evidence linking Beasley to the murders of David Pauly, Ralph Geiger, and Tim Kern, alleging that he then buried their bodies. They also believe he attempted to kill Scott Davis, the sole survivor, who identified Beasley as the gunman. All victims had responded to a Craigslist ad for a farm caretaker job. In his defense, Beasley claimed that Davis attempted to shoot him.
It misfired 3 times, about 2 feet from my face.
Prosecutor John Baumel challenged that testimony.
So Scott Davis was being untruthful about that,
Absolutely, correct? Positively, he lied through his teeth.
Investigators, however, believe Beasley is the one lying. He shifted blame to others, including motorcycle gang members, claiming they were targeting him because he was a police informant. During his testimony, Beasley stated that Geiger allowed him to assume his identity in a bizarre turn of events. At the time, Beasley was wanted for a parole violation in Texas and was attempting to avoid detection.
I thought that I was comfortable and secure living under the name Ralph Geiger.
However, the prosecutor left the jury with this question to consider.
Did you benefit from Ralph Geiger's death?
Yes.
The prosecution has rested its case, and the defense is expected to conclude its arguments the following day, with closing statements scheduled soon after. There had been speculation that co-defendant Brogan Rafferty might testify, but that will not happen. Neither the prosecution nor the defense called him to the stand, likely because they deemed it too risky to have the teen-convicted murderer testify, believing he wouldn't aid either side's case. Bizarre is a term that applies to much of what unfolded in court. Mary Jones, in her 70s, has just embarked on a new chapter in her life after being released from prison. She spent over 3 decades behind bars for a crime she did not commit. Ben Tracy shares her story.
I just knew in my spirit that it wasn't right, and I knew that God was going to open doors, in his time.
32 years ago, Mary Jones fell in love with a man named Mose Willis.
Not knowing who he really was.
He wasn't a good guy.
No.
Willis killed someone during a drug deal in an alley, and Mary Jones drove him to that location.
He forced you.
Yes.
At gunpoint?
At gunpoint, yes.
And you felt like had you not driven that car, he would have killed you.
Yes.
In 1981, Mary Jones was convicted of first-degree murder and sentenced to life in prison. However, her case was reopened with the assistance of Laura Donaldson and other law students from the University of Southern California. They argued that Jones had been abused by her boyfriend and coerced into committing the crime. A judge ordered her release, and Jones's family expressed their joy. Her daughter, Denitra, spoke to reporters outside the courthouse.
I'm excited. We got a lot of Mother Days to catch up on that are unconfined.
Okay, thank you.
She took her mom to the DMV to obtain an ID card. Mary Jones is now 74 years old.
In 32 years, what do you feel you missed?
Well, I missed my grandbabies. I didn't get to hold them on my lap. I didn't get to see them crawl. So I missed all of that. I did.
While imprisoned, Jones began a Bible study and became known as Mother Mary. Former inmate Patricia Elder was present to welcome her upon her release.
You become like family when you're there for all that many years with people,
What did you learn about yourself in 32 years in there?
I learned patience.
I would imagine you have to in that situation.
Yes, you do. You have to hurry up and wait.
She waited 11,875 days to gain her freedom. Formal murder charges and a crime of violence have been filed against Isabella Guzman, who is accused of stabbing her mother 79 times. The filing of charges was delayed today because Guzman refused to leave her cell. She was scheduled to appear in court, but court officials reported that she didn't want to leave her jail cell at the Arapahoe County Detention Center. Isabella Guzman now faces first-degree murder charges following the brutal stabbing of her mother in the face and neck at their home in Aurora. The 18-year-old smirked at the camera as she stood up and walked to the defense table, her arms and legs shackled. After the judge read the complaint against her, she looked at the camera and gestured to the area under her eyes with her index finger. Court documents reveal that Isabella had a troubled relationship with her mother, who was concerned enough to call the police on August 28th. Officers visited the home and informed Isabella that her mother could evict her due to her behavior. This seemed to calm her down temporarily, but later that evening, after her mother went upstairs to take a shower, Guzman's stepfather heard a thump, ran upstairs, and saw blood oozing out from under the bathroom door. The documents state that he later saw Guzman exit the bathroom with a knife in her hand, staring blankly and not saying a word.
I was not myself when I did that, and I have since been restored to full health. If I could change it.
Attempts to contact Guzman's stepfather were unsuccessful, as he wasn't home. Meanwhile, 2 dumpsters were filled with stuffed animals, jewelry, and other belongings, indicating that someone wanted to dispose of those items. Guzman is scheduled to return to court in Aurora. Calvin Sanford is just 15 years old and not old enough to drive. Prosecutors allege that he led police on a high-speed chase in a stolen truck, which ended in a fatal crash.
Mr. Sanford is present.
During his bond hearing, Daniel Marino, whose mother was killed in the crash, urged the judge to keep Sanford incarcerated.
I would just hate for somebody else to lose them all.
Prosecutors state that on March 12th, Sanford and 3 other minors stole a truck.
Good morning, sir. Good morning.
Police officer Darren Gibson spotted the stolen truck in East Tampa and initiated the chase. He reported that he sometimes could barely keep up with the vehicle.
At least my Explorer, it red lines at 105.
So when you say 105, you mean 105 miles per hour?
miles per hour, yes, sir.
The high-speed chase ended in Plant City, where Sanford crashed into a black Honda Civic, resulting in the death of 44-year-old Maria Torres. At the time of the accident, her son-in-law was behind the wheel.
And then my mother-in-law, she was just like hanging out of the vehicle, and like it was just the worst thing.
His wife barely survived the crash and is now in a wheelchair. Following the incident, Sanford was arrested. However, another boy, Christopher Small, fled the scene but was eventually apprehended. The judge instructed him to tuck in his shirt before taking the witness stand in court. Once there, Small was reluctant to speak. However, he later returned and identified Sanford as the driver of the stolen truck.
Pointed at Mr. Sanford now as the driver. Is that because you don't want to be accused yourself?
No.
But you were in the stolen truck.
Yeah.
After hours of testimony, the judge ruled that the teen suspect would not be released and ordered him back to jail. The bond was denied. The testimony continued in the trial of Piedrahita, who is accused of killing the father of 3 on the causeway in 2019. This marked the second day of testimony from a key state witness, and the defense had its opportunity today to cross-examine him. The witness stated that he shot and killed 48-year-old Alex Valencia on the causeway in 2019. Cesar Sosa was back on the stand.
The defendant killed Alexis Valencia. But here in court, the defendant killed him again by taking the stand and killing his character.
Video from a camera attached to Sosa's bicycle recorded the incident. Piedrahita was seen riding his bike alongside a group of cyclists when he shot Valencia. He claimed it was self-defense, but prosecutors argued that a feud had begun days earlier. Sosa testified that Piedrahita had threatened him before the incident.
Told everyone that day exactly what he wanted to do to Alexis Valencia.
During cross-examination, the defense asked Sosa if he had edited the video, which he denied. They also questioned him about why he had conducted multiple interviews with the media. The motive for the confrontation remains unclear, but Valencia's daughter mentioned that her father and Piedrahita were acquainted. She stated that her father sold Piedrahita some insurance, and that Piedrahita had called him a fraud online.
We, the jury, find as follows as to count 1 of the charge. The defendant is guilty of second-degree murder.
Piedrahita is charged with second-degree murder and has pleaded not guilty. Kirk Williams, who was convicted of beating his girlfriend, Susan Dykes, to death, received his sentence in Walton County Circuit Judge Kelvin Wells' courtroom.
All rise.
Thank you. Be seated, please. The defendant murdered Susan Dykes in her trailer by brutally beating her about the head with an aluminum baseball bat. He gagged her at some point as he carried out the murder. He stole his father-in-law's boat from his yard for use in carrying out his murder plan. The defendant wrapped her body in a blanket to transport her. Using the victim's car with the boat tied atop, he then took Susan Dykes' body to Lake Cassidy. The defendant used mule tape rope and bound her torso and both feet to 3 concrete blocks and then threw her overboard and sank her body in the lake with the intent that she never be found. The defendant was surely surprised by the body of the victim floating to the surface of the lake and being found. On Sunday evening, the 8th of October, from the Walton County Jail, the defendant phoned his wife and gave her specific directions to move some of the evidence that he had left behind at the victim's trailer. This aggravating circumstances that the capital felony was especially heinous, atrocious, or cruel was proved beyond a reasonable doubt. The crime for which the defendant is to be sentenced was committed in a cold and calculated and premeditated manner without any pretense of moral or legal justification. The court has given the jury's advisory sentence and recommendation great weight. The court has very carefully considered and weighed the aggravating and mitigating circumstances found to exist in this case, being ever mindful that a human life is at stake. The court finds, as did the jury, that the aggravating circumstances do outweigh the mitigating circumstances. Accordingly, it is ordered and adjudged that the defendant, Kirk Douglas Williams, is hereby sentenced to death for the murder of Susan Dykes. It is hereby ordered that the sheriff of Walton County surrender the defendant to the Florida Department of Corrections to be kept in close confinement until your execution as provided by law.
Kirk Williams was sentenced to death for the murder of his girlfriend, Susan Dykes. A boy convicted of murder will spend the rest of his life in prison. Coleman shot Dashia Green, and the judge handed down the sentence.
This family is absolutely devastated. They came to court for the sentencing, and they still don't have a motive to why their daughter was shot and killed.
Joshua Coleman pleaded guilty to murder and was sentenced to life in prison. He shot Dashia Green in the back of the head in an alley, and Green's mother, visibly emotional, asked Coleman why he killed her daughter while he remained stone-faced.
Why would Joshua do this to her? She didn't deserve it. She was a social butterfly. She didn't deserve it.
Last year, police discovered a girl dead in an alley. Dashia Green was known to be a habitual runaway, and her parents had reported her missing. However, this time was different, as the prosecutor stated that a witness came forward to assist the Tallahassee Police Department in solving the case.
I can't tell you enough how important it is for, if you see what's happened to someone, to come forward, and we had an individual that did that, and that takes incredible bravery.
Judge Michael Goulding asked Coleman if he wanted to make a statement.
Would you like to tell the court why you did it?
Coleman is one of many young individuals who have been certified to stand trial as an adult for committing murder.
Well, they finally starting to show these youth that you can be charged as an adult and you can do grown people time. So at any point in time, you got to think twice about what you're going to do. I'm just glad my daughter got her justice.
Joshua Coleman's family declined to comment. You can see Jefferson County Sheriff deputies walking toward the benches in the courtroom, escorting Siobhan Grant, the mother of William McLemore. McLemore, along with DeMarcus Tramber and Duan Mason, is on trial for murder.
The kind of head-shaking, eye-rolling that would ordinarily get you put in jail, particularly in light of the court's previous admonition.
Grant was sitting in the gallery, listening to testimony from the lead detective in the investigation into Nariah Miller's murder. The girl was shot and killed on her front porch in August 2014. As the detective was speaking, the judge interrupted him mid-sentence.
Stop, please. I need 2 minutes, folks. Could you all step out for 2 minutes?
The circuit court judge mentioned that he saw McLemore's mother misbehaving.
Record reflected. In response to the question, she shook her head and rolled her eyes.
Moments before the judge halted the trial, lead detective SGT. During the investigation, Scott Beatty discussed a conversation with McLemore's mother more than 2 years ago.
What did she tell you?
She said that she knew that he had had before, and I asked her, trying to, I guess, get a little bit more description.
However, that's not the account McLemore's mother shared with the jury when she was on the stand a few hours earlier.
So your contention is that you were never asked anything about handguns?
No, I was not.
And that your statement to this jury is that you were never asked about anything with handguns having to do with your son?
No, I was not.
At the beginning of the trial, the judge had another woman escorted out of the courtroom. He reminded everyone in the gallery to remain completely neutral and composed during the proceedings. The trial is set to resume shortly. The scales of justice weighed heavily as Wade Wilson confronted the consequences of his actions. Already sentenced to death, Wilson received an additional 12 years in prison following his no-contest plea to trafficking and conspiracy charges. In addition to prison time, he faces a $50,000 fine and court costs. Wilson pleaded no contest to 2 charges, one for attempted trafficking of amphetamines and another for conspiracy to traffic amphetamines. This hearing was initially scheduled for September, but state attorneys moved it up so that Wilson could be sent to death row more quickly. Judge Frank Porter accepted Wade Wilson's plea deal and found him competent, alert, and able to enter his no-contest plea. On his way out of court, Wilson also provided his fingerprints. He must pay a $50,000 fine and be ordered to serve 12 years in the Department of Corrections, concurrently with any previously imposed sentences. He must serve a minimum of 7 years. Throughout Wilson's previous court hearings, he exhibited little to no emotion, which did not change this time. However, he did address the court more frequently, mainly because he was required to do so.
Has anyone made any promises to you other than the agreed upon sentence in exchange for this plea?
No, sir.
Did anyone threaten you to get you to enter this plea?
No.
Did you read and understand the plea form?
Yes.
Do you have any questions?
No, sir.
Did you sign the plea form?
Yes, sir.
Are you satisfied with the services of your lawyer?
Yes, sir.
Has he done everything you've asked him to do for you?
Yes.
Do you think this plea is in your best interest?
Yes.
An important moment during the hearing was when the judge asked Wilson if he experienced any significant issues, to which Wilson replied, no. Throughout the sentencing, his defense attorneys argued that he suffered from multiple mental illnesses, which was part of their advocacy for him to be placed on death row. A Gwinnett County father accused of child cruelty is set to appear before a judge for a new trial related to the death of his daughter. This comes after a mistrial was declared just a week earlier. Jurors deliberated but could not reach a verdict, prompting the judge to declare a mistrial, leading to a retrial. Cledir Barros' daughter, Syra, was beaten to death. Investigators report that Sarah's stepmother struck her approximately 10 to 20 times. Sarah's stepmother has been charged with murder. Meanwhile, prosecutors argue that Barros bears some responsibility for his daughter's death, claiming that after learning about the beating, he came home and allegedly prayed over her for 10 to 20 minutes before calling 911.
I've never seen a rolling pin being used in my life in my house. We never use anything in my presence that harmed the kids. What my wife did was wrong, and she must go through the consequences. So what I'm giving her, I forgave her because I know the source of all this, but I'm not justifying what she does.
A new judge will preside over this case, and jury selection will begin anew. The alleged attack took place in the heart of downtown Detroit, near Campus Martius, a location where many people say they feel very safe. In court, the prosecutor described the suspect as someone who should be considered extremely dangerous. The details surrounding the alleged attack are shocking, as are the circumstances of the arrest of 30-year-old Lawrence Gilchrist.
That you informed the officer, quote, I knocked his ass out.
Gilchrist is now facing serious assault charges. The assistant prosecutor stated that he should remain in jail until the trial.
This person is clearly a danger to society. This was an unprovoked attack on a stranger from another country where he came up to him and he cold cocked him. The victim remains unconscious and is unresponsive, and we're waiting for status updates hourly at this point. We're not certain that the victim will survive this incident.
The man involved was visiting Detroit from Germany. According to sources, he was on a Great Lakes cruise that included a stop in Detroit.
Things happen all over in every big city, but to hear something like that, an 81-year-old man, a tourist, coming to, obviously he liked Detroit too. Sure. So it saddens me to hear that.
The alleged attack occurred on Woodward Avenue in the heart of downtown Detroit.
The suspect simply walked up to him and immediately and violently hit him. The probability of conviction and sentencing is strong, given the entire assault took place on video camera.
Gilchrist's attorney presents a different perspective of his client, describing him as a man with no criminal record.
We have a 30-year-old young man, works every day, has 2 children, lives in the city, so he has ties. It's not a flight risk.
The judge set bond at $50,000 in cash, citing pending court cases related to public drunkenness and court-ordered mental health treatment, a decision that the prosecution disagreed with.
He is, again, being bold, a loose cannon to the community.
If Gilchrist posts bond, he has been ordered not to contact the victim or go to downtown Detroit until the case is resolved. A 23-year-old Illinois man is charged with the shooting death of whitewater gymnast Kara Welsh. Chad Richards is facing a first-degree intentional homicide charge, which carries a potential life sentence. The initial court appearance was brief, lasting less than 10 minutes. However, 7 days after Kara Welsh's tragic death, the details of what transpired remain undisclosed and are being discussed behind closed doors.
This is the 115 criminal call for September 6, 2024.
Appearing via video, 23-year-old Chad Richards sat quietly in his jail-issued clothing while his attorney spoke on his behalf.
Your Honor, I did get a copy of the complaint. I have read it. At this time, we would waive its formal reading.
The complaint charges Richards with 1 count of first-degree intentional homicide using a dangerous weapon. Officials state that they were dispatched to an apartment in Whitewater just before midnight on the 30th after Richards called 911, claiming a female was dying. Upon arrival, officers found Richards in the hallway, crying hysterically. As they entered the apartment, they discovered 21-year-old Welsh lying on the floor, not breathing, with multiple gunshot wounds. A black handgun was found on the floor, and the bedroom door had holes consistent with someone punching it. In an interview with officers, Richards reportedly told investigators that Welsh was his girlfriend and that they had argued. He claimed he became so angry that he punched the door, after which Welsh allegedly grabbed his gun from the bedroom during the argument. According to the complaint, when he wrestled it from her, Richards shot Welsh with the handgun out of fear for his life. A detective at the scene indicated that the evidence suggested the shooter was standing over the victim and fired while she was in a fetal position. Kara Welsh's family attended court but chose not to speak this time. The court has scheduled a preliminary hearing in Walworth County. The heartbreaking case of Sierra Patino's death has uncovered troubling details about her final days, as described in newly released court documents. Her mother, Priscilla Torres, and Torres's boyfriend, Santiago Esparza Jr., are accused of allowing Sierra to suffer for days following a mysterious and fatal incident. Disturbingly, they left Sierra in a closet for 3 days, continued living in the apartment, and even took a trip to Galveston before eventually contacting authorities. According to Torres, the tragic events began on August 23rd when she and Sierra were at Esparza's apartment. Torres stated that Esparza was bathing Sierra while she prepared dinner. She claimed the bathroom door was locked, and despite her protests, Esparza refused to open it. When she finally gained access, she found Sierra with bruises and injuries that had not been present earlier. Esparza reportedly denied any wrongdoing, asserting that whatever occurred was an accident. Prosecutors later highlighted contradictions in Torres's statements. Initially, Torres claimed she had been the one bathing Sierra and stepped away briefly, only to return and find an empty bottle of cleaner in the tub. She later changed her account, shifting blame to Esparza for the events leading to Sierra's tragic death. According to Torres, Sierra's condition worsened significantly in the 4 days following the incident. She grew increasingly ill, refusing food, vomiting, and eventually losing consciousness. On the night of August 27th, Torres and Esparza attempted to shower Sierra to help her, but she became unresponsive. Torres said she handed Sierra to Esparza, who laid her on a bed and tried performing CPR. Despite their efforts, Sierra tragically passed away that night. Instead of contacting authorities, Torres admitted to dressing Sierra in a green romper and allowing Esparza to place her in a bedroom closet. The couple then remained in the apartment with Sierra for 3 days. When questioned about her delay in reporting the death, Torres told investigators she did not want to let her go. Surveillance footage revealed that on August 30th, Torres and Esparza left the apartment. They went to Esparza's father's house, where they switched vehicles and then spent 3 days at a hotel in Jacinto City. During this time, they even took a trip to Galveston. On September 2nd, Torres persuaded Esparza to return to his apartment where Sierra had been left. It was only then that Torres called 911 to report her daughter's death. Esparza voluntarily spoke with police the following day, September 3rd, before being arrested. His account of events differed from Torres. He claimed that after Sierra's injuries on August 23rd, they stayed at his brother's house until late that night before returning to his apartment. His conflicting statements added further uncertainty to the circumstances surrounding Sierra's tragic final days.
Yes, Your Honor, the state would ask that he be held at no bond. He is a true habitual, and we will be filing a motion to hold him.
I only see one pen trip.
I have a conviction out of Parker County in 2014 out of the 415th District Court for the felony offense of possessing a prohibited item in a correctional facility. He also has a conviction for injury to a child out of this county from 2011.
Okay, I did not see the out-of-county conviction, which is a third-degree felony. Okay,
correct.
Thank you.
Yes, ma'am.
Ms. Gonzalez?
And can I ask a further question? Was he in custody? Was it one pen trip he was there on?
No, he has one from 2014 that he did 2 years TDC. And then he got 10 years deferred in 2009, and then he was sentenced to 4 years TDC in 2011.
If I'm correct, he picked up the offense while he was in custody in TDC.
I don't see how he could have picked up.
Can you clarify that for us?
I don't know either. I just show that I just have the dates for the
What's the offense?
the prohibited item in a correctional facility.
So he was in prison at the time.
Yes, I see what she's saying. What she's saying is to hold somebody as a true habitual, they have to have been sentenced to TDC, done their sentence and gotten out, and committed another offense and done their sentence and gotten out, and now be charged with a third offense. And what Mr. Gonzalez is saying is he was still in TDC for the possession of a controlled substance in a correctional facility. So he didn't get out and commit another offense. And she's right about that.
Okay.
I didn't know if you wanted to change his position and ask for a certain amount at this point. Proceed under the no bond.
Well, in light of that, Judge, then we would ask for an upward departure from the bond schedule. I'm not sure if you are aware of the facts of this case or not, Your Honor.
I am. I read the warrant before court, and I intended to ask Mr. Esparza. Did you want to hear the allegations in the warrant, Mr. Esparza?
Ma'am, I already heard it now.
Okay, thank you. Go ahead, Mr. Sanchez. I did read the warrant.
I will say then, and as you're aware, and I'll just state for the record, that his co-defendant in this case indicated that there was evidence of injury to the child that she did not see on the child prior to Mr. Esparza possessing the child. I believe he was giving her a bath. And I would note that one of his prior TDC trips is for injury to a child. So I do have some concerns regarding community safety. And so we would ask for an upward departure in the bond schedule, and we would ask for a $100,000 bond in this case.
Ms. Gonzalez?
Judge, and if I may, the co-defendant in this case is the only evidence that's against him at this time, which case she started out by saying she was the one that gave the child a bath and then changed her story. So that is the only evidence at this time I believe the state's presenting. He has lived in the Houston area all his life. He has 3 children, a 5-year-old that he pays child support for in the amount of $500 a month. He also has a 9-year-old and an 11-year-old. He's lead maintenance, has a job, been there for the past year, making $2,600 a month. He does have several family members who would make sure he gets to court. I want to note, Judge, that he turned himself in yesterday to the detectives in this case. He has not, he's not a flight risk. He has, all his family is here. He's never been to Mexico. He doesn't even have a passport. Judge, we're asking that you set bond in the amount of $20,000, according to the PSA.
So, he go ahead.
I was going to say the injury to a child conviction is not his only conviction. His entire criminal history is full of assaultive and violent offenses involving both adults and children. With regard to the co-defendant's prior statement, I would just point out that while none of his prior assault family member convictions, as in plural, were committed against this co-defendant, the state would not be surprised if, she may or may not have not implicated him the first time around when she spoke to police out of fear of perhaps being retaliated against by him, given his history of domestic violence.
Okay, so he has 3 prior felony convictions. One of those is the injury to a child, which he did 4 years TDC. He also has a state jail endangering a child conviction. In addition to that, he has an assault family violence conviction from 2015. 2 assault bodily injury convictions from 2009 and 2007. There is an extensive assaultive history, including one involving children. Based on that and the allegations in this particular case, Mr. Esparza, I am going to set your bond at $100,000. I'll refer any request for a lower bond or a personal bond to Judge Powell in the 351st. And that is for the safety of the community based on the violent history and the violent allegations in this case.
Both Torres and Esparza are now facing criminal charges in connection with Sierra Patino's tragic death. Torres has been charged with tampering with a corpse, and her bond was set at $50,000. Esparza, who prosecutors identified as a known gang member with a history of violence, including a 2011 conviction for injuring his son, faces the same charge. His bond was set at $100,000. The investigation is still ongoing as authorities work to uncover the full details of the case and seek justice for Sierra. The trial of Ronald Newberry, accused of the brutal kidnapping and murder of Paul Bradley and his daughter Paris, entered its second day. This tragic case, originating in October 2018, has already led to convictions for 2 other individuals connected to the horrifying crime. Testimony revealed that Paris Bradley suffered torture in front of her father before both were murdered. Their bodies were discovered inside a car on Savannah Avenue in East Cleveland, a crime that shocked the community with its sheer brutality. In December 2021, one of the suspects, Cody Gibson, was found guilty for his role in the murders. The jury recommended a life sentence for Gibson, highlighting the gravity of his involvement. Another suspect, DeMarcus Shealy, has been charged in connection with the crime, and his trial is set to begin at a later date. As the trial against Newberry proceeds, prosecutors are working to hold him accountable for his alleged role in this devastating double murder, which claimed 2 lives and left an indelible scar on the East Cleveland community.
All right, gentlemen, a few important things. I'm Judge Dawson. Before we begin, I want to make sure you understand what some of your primary rights are. First of all, you have a right to an attorney, and I believe you've had a chance to speak with the defense attorney here, or you may have your own attorney. If you have not had that opportunity, we'll make sure you get that opportunity. You also have a right to remain silent, which would be expressed through your attorney, which means you do not have to say anything when I call your name. You may be asked to come to the microphone with your hands visible, if that's able, or if you're capable of having your hands visible, then that's what we would ask you to do. Otherwise, you do have that right to remain silent. And then you have a right to what's called a probable cause or a preliminary hearing. That's a hearing for the purpose of the city to give evidence to the court that a felony was committed in this city and that you are connected to it to the point where I have to send it to the felony court to be resolved, meaning the felony cannot be handled in a misdemeanor court such as this one. When you speak with your attorney, the attorney will let you know that you can either have that hearing, you can request that hearing formally, or you can waive that hearing. If you waive the hearing, you're not admitting any guilt. Basically, you are allowing the case to be sent to the county for further proceeding. If that takes place, I will also set a court date for you so that you know when to appear at the county for your further proceedings. Also, I will set a bond for you here. We will hear from your attorney as well as the city's representatives in regard to the bond. And if you are electing to have a preliminary hearing, it has to take place within 10 days if you are still in the jail. But if you are able to make your bond that is going to be recommended and set, we have 15 days to have that particular hearing. But we'll let you know all that when we call the cases based on what the request is from your attorneys. First case is 18 CRA 01163, the City of East Cleveland versus Ronald Newberry. Good morning, counsel.
Good morning, Your Honor. For the record, K. Ranke, 216-374-7660.
Thank you very much. I have here 2 counts. The first one is a violation of 2903.01, a charge of aggravated murder. And then there's a second 2903.01 charge of aggravated murder. Those are felonies of the first degree, where you're looking at least 3 to 11 years in prison, up to a $15,000 fine, depending upon the specifications added to the charge. It could be life in prison or death. And it looks like in this particular situation, they have indicated that life is a possibility as well as death. The complaint states specifically that on or about the 10th day of October 2018 in the City of East Cleveland, Ronald Newberry did knowingly, purposefully, and with prior calculation and design cause the death of Paris Bradley, while committing or attempting to commit aggravated robbery and aggravated burglary. The second charge states that on or about the 10th day of October 2018 in the city of East Cleveland, Ronald Newberry did knowingly, purposefully, and with prior calculation and design cause the death of Paul Bradley while committing or attempting to commit aggravated robbery and aggravated burglary. Counsel, in regard to the probable cause hearing.
Judge, I have gone over with my client. We would demand a preliminary examination.
Okay.
He has indicated so on the form and the advisement of rights form, which I can provide the report. But we voluntarily surrendered upon being notified that there was an active warrant. I did call the detectives, made arrangements, and turned him in voluntarily to the East Cleveland Police Department last Thursday. We were informed originally that the court date was going to be on Tuesday. It was subsequently pushed back until today. I have accompanied Mr. Newberry to the detectives to speak to them on 2 occasions, as well as provided additional information in an effort to cooperate. It is my understanding that on at least 3 occasions, while he's been in the city jail outside of my presence, the detectives have brought him up, spoke to him in his jail, attempted to speak with him, which is certainly a violation of his attorney-client privileges. In addition, Judge, we made arrangements for his mother, who is not a suspect in this case, as well as his girlfriend, to speak to the detectives. His mother was arrested. Mr. Newberry was told by the detectives that his mother was going to remain in jail until such time that he confessed. His mother has been subsequently released. We are demanding a preliminary hearing, but I would ask for the record that there be no contact with my client outside of my presence by any law enforcement. We've also spoken to the prosecutors who were present last Friday. They are also aware of my representation.
All right. Thank you, counsel. So first of all, what we're going to do is set the preliminary hearing for Monday, November 19th, and I believe we set that time for 12.
Noon.
Yes.
Thank you, Judge.
So let's do that. And Counselor, appreciate your cooperation and the involvement that you've been, the steps you've taken to make sure that your client has been presented to the East Cleveland Police Department. So I appreciate that. And I don't think it's unreasonable to make that request on the record and even in the presence of the court, that there be no contact with your client. So I do understand that. I'm sure the city understands that at this point. So we should not have any more problems in that regard. Detective or Madam Prosecutor, to the issue of bond.
Hi, Your Honor.
Sorry.
Good afternoon. For the record, Detective Joseph Marche, City of East Cleveland, assigned to major crimes in the Detective Bureau. Before you, Ronald Newberry, black male, 23 years of age. We're not going to put his address out today. We're also not going to put any evidence out there today due to the fact that there is media here. Detective's bond recommendation is $5,321,770 cash surety, and that number is significant to the victim, Paul Bradley.
Counsel.
Judge, for the record, based upon the charges, I would leave the issue of bond to the discretion of the court.
Okay. All right. And I think what's important here is a couple of things. One is that obviously there's no more contact. We want to make sure that's done correctly and properly. We're going to set the prelim for Monday. And because of that, I think the bond recommendation, I don't see an adjustment that I would make that would make a big difference as far as Mr. Newberry being released today. So I will keep the bond set at the $5,321,770 and set the preliminary hearing for Monday at 12 noon.
Thank you, Judge. I just will ask to raise the issue of bond again after the preliminary hearing on Monday.
Absolutely.
Thank you, Judge.
Thank you very much.
Thank you, Your Honor.
On March 24th, 2022, Ronald Newberry was sentenced to life in prison with the possibility of parole after serving 65 years for his role in the 2018 kidnapping and murders of Paul Bradley and his daughter, Paris. He was found guilty on multiple charges, including aggravated murder, kidnapping, and aggravated arson for his involvement in the brutal crimes. North Olmsted police reported that the incident occurred just after 3 p.m. on June 3rd, when Julian and his mother, 38-year-old Margot Wood, were stabbed in the parking lot of the Giant Eagle located in the 27200 block of Lorraine Road. Both victims were rushed to the hospital for treatment. Tragically, the Cuyahoga County Medical Examiner's Office later confirmed that Julian succumbed to his injuries. However, Margot is expected to recover fully, according to police. When officers arrived on the scene, they encountered the suspect, identified as Bianca Ellis, walking toward Dover Center Road while holding a knife. She was taken into custody without resistance. Police have stated that their investigation suggests the attack was a random act of violence, as Ellis had no previous connection or interactions with the victims before the stabbing. Ellis's arraignment follows her indictment on multiple charges, including 1 count of aggravated murder, 2 counts of murder, 2 counts of attempted murder, 2 counts of felonious assault, 1 count of endangerment, 1 count of tampering with evidence, and a misdemeanor theft charge. During her arraignment, which was held via video, Ellis appeared with her head lowered as Judge Nancy Margaret Russo posed several questions. Ellis remained silent for many of them, declining to respond.
Good morning, Your Honor. Ashlyn Carroll on behalf of Miss Ellis. We would
Excuse me, I'm going to ask her the questions.
Oh, sure.
Miss Ellis? Miss Ellis? Miss Ellis?
Yeah.
Please raise your head.
Where is it coming from?
I just need to ask you a few questions. I need to make sure you understand them. Do you have an attorney?
I'm gonna look for one.
Okay. Do you have the money or means to hire an attorney?
Repeat that.
Do you have the money or means to hire an attorney?
Possible.
Okay. Have you received and read your indictment?
I don't know.
You don't know if you've received it? Have you received it? Ma'am, just tell me whether or not you've received it, please. Miss Ellis, we'll be out of here in a few minutes if you just answer these questions. No, I haven't. Miss Ellis, have you received your indictment?
What was her name?
Miss Ellis?
What was her name? The judge. What's the judge's name?
Russo.
Russo?
That's right.
Russo. Russo with an R?
Have you received and read your indictment? Yes or no? If you haven't received it, I'm going to send it over there. So you need to tell me that. Miss Ellis, why don't you want to answer these questions? All right, we'll come back to her when she's ready to talk to me.
Your Honor, could I just let the court know our office does represent Miss Ellis on another case, and
I understand.
There are some mental health issues, and I do believe they have
I'll come back to her.
Okay, just to clarify, I do believe she hasn't been on her medication.
I will come back to her.
Okay.
The outcome was much the same when Ellis was brought back for the continuation of the video arraignment. She kept her head lowered and remained unresponsive to several questions posed by the judge.
Ellis? Miss Ellis? Miss Ellis?
Thank you.
Have you received the indictment?
I don't know.
Would you like me to send it to you or read it out loud to you?
Thank you. Thank you.
That's not responsive. Would you like me to do either of those things? Miss Ellis? Do you understand on the indictment that the state has reserved the right to add the death penalty? Do you understand that? Have you read that?
ASAP.
What's ASAP?
What's video court?
Your Honor, we would like to enter a not guilty plea for Ms. Ellis. We would like to waive a reading of the charges, waive any defects in time or manner of service. As I said, our office has reached out to the jail to get mental health services for Ms. Ellis. They were working with her on a previous case, and our social worker has gotten involved. So we would like to ask that counsel be appointed and that the public defender's office be one of those two attorneys, and ask for a reasonable bond.
Has she received the indictment? Have you discussed it with her?
I personally have not, but I do know attorneys from my office did go see her last week, and that there were some notable mental health issues.
Did they go with the indictment?
That I don't know.
Well, then how am I expected to arraign her?
I would like to waive that time period for her.
This could be a capital murder case. I don't think that's appropriate. So if somebody wants to go over there now and go over it with her, I'll hold it. So send somebody over there.
I'll reach out to the office.
Okay, we'll come back.
At that point, a defense attorney requested to enter a not guilty plea on Ellis's behalf, citing concerns about her mental health. However, the judge interrupted the proceedings, emphasizing that this could potentially be a capital murder case. The judge then directed that an attorney meet with Ellis to review the indictment in detail. Shortly afterward, Ellis was brought into the courtroom in person, where she stood before the judge.
Ready, Your Honor? I'm ready.
Going back to case number 692604, Bianca Ellis.
Hello, Miss Ellis. Do you have an attorney? You do? Do you have the money or means to hire an attorney? Have you received your indictment?
I don't.
Okay. Have you read it?
No.
You have not read it.
I read
Okay.
it to you back there, right? I did not.
We have a copy here. You can read it.
I don't want to read it.
You don't want to read it?
No.
Are you willing to accept that the public defender has read it to you?
I asked her not to.
I'm sorry.
I asked her not to.
You asked her not to. Well, but she did read it to you, correct?
No.
She didn't read it to you.
I read it.
Okay, well, we can read it in open court. I can find it. Okay. It's a 10-count indictment. Count 1 alleges that on or about June 3rd, 2024, the defendant did purposely and with prior calculation and design cause the death of J.W. 10/29/2020. The state of Ohio reserves the right to seek a superseding indictment containing the appropriate 2929.04A aggravating circumstances specifications. And so you understand that means the state is reserving its right to add a death penalty specification. Count 2 alleges that on or about June 3rd, 2024, that the defendant did purposely cause the death of J.W. 10/29/2020. Count 3 alleges that on or about June 3rd, 2024, the defendant did cause the death of J.W., date of birth 10/29/2020, as a proximate result of the offender committing or attempting to commit an offense of violence that is a felony of the first or second degree, to wit, felonious assault, Ohio Revised Code Section 2903.11A1, and or endangering children in violation of Ohio Revised Code Section 2919.22B2. Count 4 alleges that on or about June 3rd, 2024, the defendant did knowingly cause serious physical harm to J.W. on date of birth 10/29/2020. Count 5 alleges that on or about June 3rd, 2024, the defendant did torture or cruelly abuse J.W., date of birth 10/29/2020, a child under 18 years of age, and furthermore, the violation resulted in serious physical harm to J.W., date of birth 10/29/2020. Count 6 alleges that on or about June 3rd, 2024, the defendant did attempt to purposely cause the death of Margot Wood. Count 7 alleges that on or about June 3rd, 2024, the the defendant did attempt to cause the death of Margot Wood as a proximate result of the offender committing or attempting to commit an offense of violence. It is a felony of the first or second degree, to wit, felonious assault, Ohio Revised Code Section 2901.11A1. Count 8 alleges that on or about June 3rd, 2024, the defendant did knowingly cause serious physical harm to Margot Wood. Count 9 alleges that on or about June 3rd, 2024, the defendant did, knowing that an official proceeding or investigation was in progress or was about to be or likely to be instituted.
Ellis responded to the judge's questions in a whisper. As the judge read through the charges listed in the indictment, Ellis occasionally smiled before ultimately entering a not guilty plea. Before the judge announced bond, Julian's father addressed the court, sharing a heartfelt statement.
Good morning, sir. Could you start with your name?
My name is Jared Wood, father of the deceased, husband of Margot. Your Honor, that day, 1 week ago, she took everything from us. There's nothing that could ever replace my son, or anything that my wife and I, or even our other kids, are going through. It's horrendous. And I really wish no bail, period, or extend it to the max limit possible that you can, at the very least. Just do whatever you can to keep this monster behind bars.
Thank you, sir. Is there anything else you would like to say?
That'll be it. Thank you, Your Honor.
Thank you. Is there anything else before I pronounce bond?
Your Honor, we would just ask that you consider assigning the Public Defender's Office, recognizing this is not our number. We did represent her at the first appearance unit. I did meet with her on Friday. We have had contact with her family and begun working on the case. Thank you, Your Honor.
When the original bond was set out of Muni Court, the bond was set at $1 million, and it was before the passing of one of the alleged victims. I do not believe that bond is appropriate given the change in circumstances and the allegations that are contained in this indictment. Bond is set at $5 million, cash, surety, or property. GPS, no contact with any surviving victim or victim's family. DNA order. Judges John Russo, pretrial is June 17th at 9 a.m. I'll assign counsel.
Thank you, Your Honor.
Bond was set at $5 million for 32-year-old Bianca Ellis, the Cleveland woman accused of fatally stabbing Julian Wood in a double stabbing outside a Giant Eagle in North Olmsted. In September 2024, she was deemed incompetent to stand trial and ordered to undergo treatment at a psychiatric facility. A judge also required her to take prescribed medication as part of her treatment, leaving the possibility open for a trial if her condition improves. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.